I rise to speak on the Penal Code Amendment Bill and on the petition I presented to Parliament earlier. I will first speak on two aspects of the Amendment Bill not related to Section 377A, and then on Section 377A and the petition. The Penal Code is one of the most important statutes that we have because the criminal law touches so many people so intimately. This bill represents the first review of the Penal Code in 22 years. It seeks to do a lot, and yet it leaves so much undone. Sir, I now turn to the petition I presented to this House earlier, which argues that Section 377A will be unconstitutional upon the repeal of Section 377. For ease of convenience, I will refer to Section 377A as 377A and Section 377 as 377. The Amendment Bill amends 377 to legalize private, consensual, anal and oral sex between heterosexual adults. But 377A, which criminalizes the same acts between men, is retained. This discriminates against homosexual and bisexual men. The amendment of 377, without also repealing 377A, is therefore unconstitutional under Article 12(1) of the Constitution, which provides that all persons are equal before the law and entitled to the equal protection of the law. That is because it does not satisfy the legal requirements for derogating from Article 12(1). A valid derogation from Article 12(1) must satisfy the rational nexus test. That is, it must be rationally connected to a legitimate purpose of the statute in question. So we must first consider the purposes of the Penal Code. The preambles of both the Penal Code and the Amendment Bill are silent on this. So let's turn to what MHA has said. Its public consultation paper on the draft Amendment Bill, dated 8th November 2006, stated that the review is intended to make the Penal Code more effective in maintaining a safe and secure society in today's context. So, according to the government, the objective of the Penal Code is to maintain a safe and secure society. But 377A criminalizes consensual sexual acts between men, even if it takes place in the privacy of their own homes. How does the private sexual conduct of consenting adults make Singapore unsafe or less secure? Furthermore, criminal lawyers generally accept that the criminal law should be concerned with two elements, and two elements only: harm and culpability, of which only harm is relevant here. Professor Michael Hall teaches criminal law at the NUS Law Faculty. In a recent article, he explained that criminal activity must entail harm to others that is recognizable and tangible. In other words, if an act does not harm others, then it should not be a crime. This is taught to first-year law students in the first few weeks, and indeed, I recall being taught this over 10 years ago. Professor Hall went on, and I quote, "The government has been strangely silent about the harm that 377A is intended to prevent. Indeed, consistent statements over a number of years from the highest officials of the land lead any reasonable observer to think that the government no longer believes, if indeed it did before, that the sort of activity contemplated by 377A is harmful at all. If corroboration were required, it lies in the repeated assurances of the government that 377A will not be enforced, apparently because there is no harm to be prevented, no offender to be rehabilitated, no potential offender to be deterred, and no victim to be satisfied." One might, of course, disagree with the government's position on the harmfulness of 377A activity. But once that position is taken, how can it be right for 377A activity to remain a crime? The Law Society, in its submission to MHA on the draft amendment bill, similarly noted, the criminal law's proper function is to protect others from harm by punishing harmful conduct. Private, consensual, homosexual conduct between adults does not cause harm recognizable by the criminal law. Thus, regardless of one's personal view of the morality or otherwise of such conduct, it should not be made a criminal offence. Private, consensual, sexual adults between adult males does not impact on the safety and security of society. Furthermore, it is accepted that the criminal law addresses activities that harm others, but the government seems to think that 377A does not cause harm, that the activities governed by 377A does not cause harm. So how can 377A possibly be linked to a legitimate purpose of the Penal Code? The answer is that it does not and it cannot. And the government has effectively admitted this. It does not seek to justify the retention of 377A on grounds of societal safety and security or of harm to others from the conduct contemplated by 377A. Instead, its reasons for retaining 377A are that the majority of Singaporeans disapprove of homosexuality, and so 377A should be retained to reflect or signpost this majority view of Singaporeans. But reflecting the morality of the majority is not a stated aim of the Penal Code, nor is it an accepted objective of the criminal law. Clearly then, 377A has no rational connection with any legitimate aim of the Penal Code. Its retention, which leads to different treatments of men engaging in oral and anal sex, and of heterosexual adults doing the same, without any legally acceptable justification, must therefore be unconstitutional. I would even argue that there can be no legitimate aim of the Penal Code with which 377A can be rationally connected, so as to justify its retention. The amendment of 377 permits heterosexual adults to engage in private, consensual, oral and anal sex. By definition then, we are saying that there is no harm arising from such private and consensual acts between heterosexual adults. Why should it be any different when those acts are performed between adult men? What is the differentiating factor that leads to harm? There is none. There is no harm that will be recognized by the criminal law. It is not harm that results from such acts being performed between adult men, but the moral disgust that the majority says it feels. But there is a very good reason why the criminal law should not reflect public morality, and that is because doing so can lead to the discriminatory oppression of minorities. In times past and in other countries, public morality and disgust have been used to justify slavery, discrimination against racial and religious minorities, and discrimination against women, including not permitting them to work or to vote. All of these are now universally recognized as being wrong and immoral. Let us not perpetuate or repeat the mistakes of others in the past. Sir, the signposting argument is fundamentally flawed. It is couched in the language of the majority. But let us not forget another phrase involving the majority, the tyranny of the majority. That is precisely why the constitutional guarantees of equality and equal protection are entrenched as a fundamental liberty in Article 12.1. Even if we accept the signposting argument, the amendment bill seems to reflect public morality in a selective and discriminatory manner. It is surely undisputed that society views extramarital sex as immoral, and surely most Singaporeans disapprove of prostitution and all types of discrimination, such as age, racial and gender discrimination. But we have not criminalized any of these. Indeed, the amendment bill even repeals Section 498, which makes it an offence for men to entice, take away or detain a married woman with the intent of having illicit intercourse with her. The reason given is that it is an archaic offence which is no longer relevant in today's context. But public morality in today's society remains firmly opposed to extramarital sex. So why do we selectively reflect public morality with respect to private consensual acts between adult men, but not public morality on adultery? Why are we not signposting society's disapproval of adultery by retaining Section 498 without proactively enforcing it? The Senior Minister of State has argued that repealing Section 498 is not an endorsement of adultery or premarital sex. In the same way, repealing Section 377A is also not an endorsement of homosexuality. The inconsistency is discriminatory. And taking the signposting argument to its logical conclusion, if we repeal Section 498, are we then telling the world that seducing a married woman, hence leading to adultery, is acceptable? By lifting marital immunity in limited circumstances, are we endorsing marital rape in the other circumstances? Signposting is all or nothing. We cannot signpost selectively with some provisions reflecting public morality and others not. It does not work that way. It is a fundamentally flawed argument that does not stand up to logic or reason or the principles of a democratic society, and so we should shy away from it. Sir, Mr. Cheng, a Singapore graduate student in the US, emailed this to me, and I quote,